I'd like to get started if we could, please.
It's not working.
Yeah, this is working now. I'd like to get started if we could.
Ah, those guys chickened out.
The
You sit here. Let's have. Do I have to sit with
the
Brunswick?
last part of our program.
I don't want to see Brunswick. There he is. You're not sitting beside me. Everybody's looking. I wish to barricade the door.
The last part of our program is a discussion about what to do when purchasers don't want to close. The panel is already arguing because they don't know where they want to sit. But let me just give you a brief introduction to the players, and then I'm going to have the luxury of sitting back and hopefully relaxing as opposed to working on this program. Paul Perell is in the middle. He is the moderator. Paul is well known to everyone as a great legal thinker, sort of comes to the real estate bar through the back door, having been a litigator, and really is a prolific writer on real estate issues. To his right is Reuben, who you've already had the pleasure of listening to. The other two guys up here, on your far left is Allan Sternberg. Allan is a partner at Goodman and Karr. He acts for developers frequently. He has been involved in some of the major real estate litigation and decisions that have been decided over the last number of years. And right beside me is Stephen Brunswick. He is also a real estate litigator, and he also acts for developers, real estate, and has done a significant amount of real estate litigation over the years as well. So me, I'm turning everything over to Paul Perell, and at the end of the program, which will be at 4 o'clock on the dot, I will say my farewells and goodbyes, and everybody's free to go. Thank you.
Good afternoon. The format of the panel is to be a free-flowing conversation about the problems associated with a problematic real estate transaction, particularly from the vendor's point of view and from the lawyers acting for the vendor when they find themselves in circumstances where they fear that the transaction is going to go awry. Well, that's the main perspective. I think that before we're done, we'll also be able to have a look at some of the issues from a purchaser and a purchaser solicitor's perspective. I'm also going to invite from time to time the audience to get involved if you want to join in the fray. We've had, this is the third time this group has gotten together with this topic. We've had 2 practice sessions and neither of them were the same. So I have no idea how it's going to work out this afternoon. So let me begin, and I'm going to begin with Stephen, and the question that I'm going to start with is, Stephen, when do you start to think about the problems of a purchaser who will not close?
Well, I think I've mentioned this in our 2 previous sessions. I practice defensively, and I think although one may wait till they get a wacky requisition, I think that you have to think right from the outset, from the moment that you begin to organize your file, you have to consider that the deal that you're handling might go awry. So, I think it's from the time you instruct your clerk or begin to review the agreement of purchase and sale yourself, you've got to set up the file in such a way that you cross your T's and dot your I's.
All right, well, any sort of particular tips about how you dot those I's, cross those T's, and set up the file, particularly taking the situation of a subdivision transaction?
Well, like from my point of view, a subdivision is different perhaps than a single one-off purchase. You have to consider what might be the types of problems that you're going to encounter, like and create a checklist. And I think that you create a checklist and you have that available for each purchase. Make sure that you have all of your documents in order. So I would start off with a checklist, whether you give that to your clerk or have access to it yourself. Begin your administration by organizing the type of problems that you might encounter and the types of things that you have to deliver on closing.
All right, well, let me turn to the situation where you're moving from the practicing defensively in a general sort of way to practicing defensively in a particular way because you have an inkling that there's something awry. And let me pause on that, and I'll ask everybody on the panel this. How can you tell? What are the signs? What's the smoke for a problematic transaction? Alan?
Well, I really don't care about the question. I don't know why Sid tried to restrict my practice to acting for developers. Maybe that's why I'm getting no referrals from you people. Purchaser, vendor, I don't discriminate. Try and answer the question, which really is not within my purview of expertise, because it's really more that the solicitor would experience that. By the time someone comes to the litigator, you're much more advanced than worrying about the file going awry. But what I've seen when I review files and take them to litigation is suddenly the requisitions that are coming in are 4 pages or 5 pages, and you can just see that somebody's getting a sense that there's not going to be a closing. That's really all I can add to that.
I personally think that what a lawyer has to be aware of, purchaser or vendor, is you have to know the market conditions. I know I practice in real estate doesn't mean I ever know or ever give advice to a client as to whether to buy or what to buy or what price to pay. But we know when we're going into an inflationary market or we know when we're going into a recessionary market. If you're acting for a vendor and you see that the market, or whether you're reading in the paper or you see what's happening to market, and you know that the price that the purchaser has signed that agreement for, the prices are going down or mortgage rates are going up, because sometimes it's not the fault of the purchaser, may not get the funding, then you start really worrying about it. I once had a secretary that asked, right now I handle more transactions that don't close, but when I was handling transactions that did close, my secretary one day said to me, "Why is it you sometimes answer requisitions?" This is a true story, this was a question. "And sometimes you never answer the requisitions." And I said, "When the price of the property has gone up, I don't answer the requisitions. When the price of the property has gone down, I answer every requisition." So that is the first thing to watch out for. Watch the market. I'll tell you, the market's gone way up and you're acting for a vendor, and you're acting for a purchaser, watch what you're doing. And be careful of requisitions. You might send in a requisition, the vendor might sign back and say, "I can't answer the requisition, deal's off," but we spoke about that earlier.
All right, well, Sid, let's assume that the market is going down, and that might give you an inclination that purchasers might be seeking outs. All right, what do you take, reading between the lines of the requisition letter?
Well, you know that somebody is actually going to be trying to reserve some rights. So they may be throwing the kitchen sink at you. I think that the most important thing to do is make sure that your staff know the warning signs as well as you do. And I know that in your offices, in my offices, we do a lot of delegating. As a matter of fact, we probably got a lot of residential transactions really being run by our staff. So that it may not be until much later in the piece that you start really hearing from your staff that something is going funny. Like you start getting letters day in and day out from the other side asking for more and more things. Or you start to get a sense that as rates have fallen, somebody may not be able to get as much money as they need, and you get a call and somebody says, "Will you take a VTB in order to make the deal happen?" And at that point, again, it's time for the lawyer to take the file back. Even though may not be your style, I've seen it on the LPIC side, and that where claims are made against lawyers, that they haven't made the file their own again. It's all well and good, and when the market is steady, the market is rising, let your clerks do the deals and stick your nose in wherever you feel it's right. But if you start getting those signs like the VTB or requisitions or more demands or nutty requisitions, somebody says, the fence isn't online, it's out by 2 inches, that's a good sign that that somebody is looking for some protection.
All right, well, no, what do you do? You've taken the file back. Now what do you do?
What do I do? I call Reuben. I take a good hard look at the requisitions. It's at that point that I will really look at papering the file and making sure that everything is absolutely right. I will write the letters to the other side. I will, as Reuben says, I will answer the requisition letters. If I have to, God help me, I will look up law and throw law back at them. I will make sure that my position is clear. One of the things I won't do is I won't threaten at that stage, because once you start to threaten, like, I don't like what I'm hearing, so I'm going to hold you strictly to the terms of the agreement of purchase and sale, those kinds of letters, and we've all seen those. Be very careful. You start treading on dangerous ground by perhaps starting to impose obligations on yourself that you didn't otherwise have. So take it step by step, but I would make sure that I'm papering my file, make sure I got my discharges, make sure I've got my assumption statements and all the other stuff that I'm going to need in order to make that deal as clean as possible.
All right, now, so far we've been talking about having a premonition that there's a problem because of the nature of the requisitions. And we'll come back to requisitions in a minute. But I tossed this up. Any thought of asking the obvious?
Well, you going to close?
Going to close?
Well, I think that you come to a point when you have to do that. You might have to do that, but I really think that you've got to deal with the problem and look at the available timing between the first time that a problem comes to your attention or you have the inkling and when the transaction is supposed to close. Then you can make a decision as to what might be an appropriate time to make that call to the other side. But I think at first you got to do your best to review what the problems are and determine whether or not you can provide a satisfactory response to them. And if you can, you should deal with them quickly, provide your responses as long as you're relatively certain that your answer deals with the problem, and then watch to see if, in fact, there are any other telltale signs.
All right, well, I asked Ruby about telltale signs. Do you phone up the other side and say, are you serious about this requisition?
That, to me, is one of the toughest questions a lawyer who is acting for a purchaser is going to face, because that's what I'll do. If I get into requisitions, I see the market has gone down, I'm getting a little bit nervous about it. You've requisitioned something about a discharge of a mortgage, and it's not an institution. And so I'm going to call you up, and the agreement says you're entitled to a discharge. It's not an institution. I might have trouble getting that discharge, and I might have trouble answering a couple of small requisitions. So the first thing I'm going to do is phone you and say to you, are you serious about closing? And you have been retained by your client that get out of the transaction. And I've called you, and I've asked you bluntly, and what's your answer? And that is a difficult thing to deal with as a lawyer who is getting that call. So I think what I'd like to do is maybe throw it back to Allan or a litigator or you.
Well, I don't think it's so.
I'm not finished.
I thought you were.
He's only sort of throwing it back to you.
Rhetorical throwing
It was
back.
a throwing back rhetorically, that's right.
You're finished now. In any event, I don't think as a purchaser's lawyer, you clearly couldn't divulge your client's a communication to you that you're not going to close. That would be used in court, and you'd probably be negligent for disclosing it. From your professional relations with each other, and this question came up during our rehearsals, but whether you trust the other side, you know the other person, you've done it for years. I mean, the best, I was giving it some thought in the shower, that's what I think about these days, that the best you could say is do what you have to do. That would send the signal that if you're acting for the vendor, that he or she makes sure that everything is papered properly and that nothing is left to so-called trust at the end where you'll take a personal undertaking. But clearly as a purchaser, to say on the record, and we've had some discussions as to whether, even if you say without prejudice we're not closing, whether that will come out. Stephen seems to think that no matter what you say or what you write in your file, it's going to probably, a very big risk that it'll come out at trial. Somehow, we'll get it, or if you're hiding it, we'll make you look bad for stonewalling. So we'll make you look bad either way. But I guess, look, your primary duty is to your client.
Well, let me bounce the same problem back to you, Sid, and put yourself in the shoes now of someone acting for the purchaser. Have you received those calls, and how do you deal with them? Where you know that the other side is now fishing for information about whether they should make Herculean efforts to answer the undertakings, or really they know that they're really hoping that you don't.
Receiving that phone call makes you damned one way or damned the other. And I'm not so sure that there is a right way to answer that, other than to say, I can't talk to you. And that may be the signal as well. But in some respects, if somebody calls me and says, are you closing? I say, right now, assume that I'm closing.
Well, I don't want to jump in here.
Yeah, please jump in.
I'm not the comedian on the panel. I mean, so just from a very serious point of view, I said, and Allan raised this, that whether you're handling a piece of litigation or any other transaction, you should always make a basic assumption that what you're doing and how you're conducting yourself on the file will ultimately, be viewed under a microscope. And we've heard about concerns vis-a-vis the client, who you take instructions from, and you've got obligations under the rules of professional conduct to other counsel and to the profession at large. And I think you have to go back to those 2 points and say to yourself that, sure, if I have a valid reason for getting out of this transaction, no one has yet decided, no court has yet decided, no government has legislated that you can't rely on your strict legal position. And I think that the way courts are going these days, and candidly, there's I don't want to use the word, I've got to be careful on how I say this, but what you tend to find is a broader brush approach to judicial decision-making now at the lower levels than you might have found in the past. And so I think that you go like this, very simple. You make your client aware of the risks of relying on technical or strict legal rights, and you make your client aware up front that you have to be straightforward with the other side in the case. So when the guy, because our courts are all saying what's fair, what's good faith, what's material, and they're looking at these things. So when the guy makes the call to you, you can say to him strictly, my client is a party to an agreement of purchase and sale, and my client is aware of the obligations under that agreement, and my client is relying on its rights. And therefore, nothing you have said can ever come back to bite you in the wrong places. I mean, that's how I would handle it.
Yeah, I think I can add
Who talks like that?
You do.
Whatever.
I think I can add this observation about the conversation. As far as I'm aware, there's no obligation on any party to a contract to swear an oath of allegiance to the contract. And so, in a sense, it's a difficult conversation because you're not entitled to ask the other side whether they meant their promises. So I think your answer is correct, that you can respond and say, or combine your answer and Sid's answer and respond by saying, my client has entered into a contract and he expects or she expects it to be performed.
And your firm always does that to my clients, by the way.
Glad to hear it. Ruby.
Whatever it is, you have to, whether people talk that way or not, you have to be very careful because there's a case that's dead on that point, what is used. What happened is the lawyer for the vendor, the market had gone really down, and the lawyer for the vendor was transferring the file over to somebody else in his office. And what I'm reporting is exactly what the case talked about. And so what the vendor did is, because he wanted to get the other lawyer was taking over, he called the purchaser. And he said to the purchaser, "Are you closing the transaction?" And the purchaser said, "Yes." Ha ha. And what the court said is the court said, the purchaser's lawyer laughed when he said that, which immediately put the vendor under suspicion that the transaction might not close. So the conversation must have gone something, "Are you going to close?" "Yep, we're closing." Like, are you crazy? So you have to be... So you really do have to be careful. The other thing is that I just want to point out, if I call you up and I say, "Will you take my undertaking? You'll pay the money to the mortgagee. My client's out of town. I'll give you the undertaking. We'll hold the money in trust. Will you take my undertaking?" That's a tough call, too, because at the time that I'm asking you to take the undertaking, your client may want to close, and you don't think that there's anything wrong with that undertaking, and you think that I am going to live up to it. But what if about a month later the market changes, and you can't use that anymore, the discharge of the mortgage? So the practice of real estate, in most cases, we close the transactions. I think what I'm trying to say is in those times where there's a market change, fluctuation in interest rates, you have to be very careful. And you have to be careful what you're saying. And, we don't talk that way, but it's true. If I call you, you won't take my undertaking, and you give me the answer that's saying, then I'm going to be suspicious. Then I'm going to worry about it. And you have to take all those things into consideration.
Yes, ma'am.
Why would you even ask me to take your personal undertaking, given that we are discussing a private mortgage, considering what the Law Society has told us we have to do for private mortgages?
No, because, you see, the Law Society has set down guidelines with respect to institutional mortgages. Law Society is not saying to you, you can't take my undertaking. If you make the direction to a private individual and the money's going to be held in trust, and you say, take my undertaking, it's risky whether I'm going to want to give my undertaking on a private mortgage. So my undertaking might be that if I can't pay it off within a certain day, I'll bring a court application. So you have a right to take my undertakings whether I want to give it on behalf of a private client.
I take exception to that. Second best, maybe, but.
My understanding is the Law Society says to us that if you take it upon yourself to take someone else's undertaking without getting instructions from your client to take that undertaking, give that undertaking.
That goes without saying. I'm sorry. I should have qualified that. That was a case called Polishchuk. You're absolutely correct. You cannot give an undertaking. In that case, the lawyer gave an undertaking to discharge a mortgage. It turned out that they paid the lawyer fraudulently took the money. It had a tragic ending. There was a suicide involved, and the question came in, was the lawyer responsible for accepting an undertaking? And the court says you are. So you have to speak to your client. The world just doesn't work that way. When we take an undertaking, we don't always call the client. Should you? The answer is yes.
The Polishchuk case, is probably a dividing line in terms of the standard of care and relying on custom. I mean, up until Polishchuk, the conventional wisdom was to accept undertakings and not to necessarily ask your client for instructions, because that was the practice in the profession. I happen to know this because I was the junior of the losing counsel in the Polishchuk case. And every lawyer who testified in that case said that the practice in London at the time was to accept the personal undertakings. And the lawyers involved had done this in London countless times without difficulties. But the court said that's a risk that you take if you don't get instructions. Since then, the practice has developed and changed in a different way.
Perell decided that.
You're right.
Perell. Who decided that case?
Justice, I think it was Justice Perell. I think so. Went to the Court of Appeal. Yes, sir.
From a practical point of view, how are you ever going to get instructions? You're going to talk to your client in a residential real estate deal, and you're going to say to him, Mr. Client, this guy has a private second mortgage, and I'm going to take a personal undertaking from the vendor's lawyer to discharge this mortgage. The client's eyes glaze over, and he says to you, well, what do you think I should do?
Paul, we're way off track.
Let them.
Well, on the Polishchuk case, there actually was some evidence about that too, and that was an argument that was made in the Polishchuk case. But it's in part for those reasons that the guidelines were introduced to regularize this and to deal with the situation to make it as safe as possible for the client. But let me.
But just forget, moving off, but to bring that back into focus, you see, at the time that case was decided, the request and the responsory undertakings was more in tune with what might have been telltale signs then as to a transaction going awry. Those signs, that may not arise these days because of the guidelines that the Law Society has issued, or the awareness that you all have as practitioners as to whether or not you'd ask for them or accept them or get instructions. But so the facts may, the specific undertaking may not be on topic, but the fact that making certain requests that are unusual is a telltale sign brings us back to where we want to go today in the panel discussion.
Well, about when we were discussing this as a group the last time, and we drew a sort of distinction between various kinds of requisitions, and if you add what's going on in the marketplace at the same time, whether the marketplace is going up or marketplace is going down, and look at those different kinds of requisitions, it may lead to some defensive responses or some offensive responses. So what we did when we discussed it the last time, and I'm going to attempt to get the panel to repeat the sort of insights they provided then, is we identified sort of the bogus requisition, a requisition that appeared not to have very much merit. How do you respond to it? The contentious requisition, which seemed to be a requisition that had some legitimacy to it, and the meritorious and strong requisition. All of those are possible requisitions that you could get in a requisition letter, and all of them may give you signs that the transaction may be going off the rail and you may have a purchaser who won't close. So perhaps with the assistance of litigation counsel, or perhaps without, how do you respond to those various kinds of requisitions?
Before, excuse me, before I just specifically address each of them, just generally, so you understand that when a litigator gets the file and what goes on after the litigation has started, the deal hasn't closed, and I've always still struggling with what courts do. I think a lot what I've seen in about my 25, 30 years in practice is a lot of solicitors seem to be very technical and insisting on their strict legal rights, and you can sort of see that in the files, and strict legal positions. Then in the last 20, 30 years, with the development of good faith performance in contracts and a lot of decisions from the Court of Appeal saying a good faith obligation to close the transaction, I mean, there's a complete, there's a great tension there. And you have to understand that when the case comes, most of the cases that I argue on aborted real estate transactions, I focus mainly on good faith and try and show the other side was the bad guy who didn't really want to close. And doing that, we're all anal retentive. We look at every word you wrote. And we look and see, oh, look at that bogus requisition. That's terrible. That's a sure sign. And I know we weren't supposed to say war stories, but I had a case before Mr. Justice Montgomery. There was a mortgage that was clearly discharged. The discharge was in the purchase, in the title, in the purchaser's hands. But for some odd reason, the registrar hadn't stroked it out. There had to be a line through it. And I don't do title searches, but so when I was cross-examining the purchaser's lawyer as to, well, you had the discharge, you knew it was just an oversight, there was no risk to your title, and then he basically admitted it, and then the judge, Montgomery, looked down at him and says, is that what you do all day? So understand, you don't want to be there with that bogus requisition. So that's the first thing, don't make it. Well, because it's going to come back to haunt you.
That's true, but Allan made a comment earlier. Okay, I thought you were. Go ahead.
He said contentious and meritorious. The contentious requisition, or getting to the second one, what's good is what you should do. I mean, as a purchaser, you've got to be very careful because you know you're not closing and you're trying to get out of the deal. So don't be cavalier or whatever, because it's going to come back to haunt you. I guess the only thing you can do is rely on your strict rights and hope that some judge will have mercy on your client, especially if it's against a developer. And you can make up in the defense, we'll make one up of a misrep, and we might succeed on that. Suddenly they'll remember that it was a guaranteed price or something. In any event, from a vendor's perspective, what you should do is just appear reasonable. Try and address it. Don't be cavalier in saying, I'm not answering it. Submit solutions, title insurance, V&P applications. Bend over backwards to accommodate the recalcitrant, and you'll look good at that. Now, meritorious, if there is a good, and I know Reuben had a case I'll let him expand on, if it is a good requisition, you as vendor, do you want to get out right at the beginning instead of saying, well, jump in the lake, it's not good, and then generate 5 years of litigation and find out it is? I prefer the latter route, but there's a selfish interest in that.
Go ahead. Sorry, I just say there's problems that you have if you say it's not a good, you could run into if you say it's not a good requisition, and then, it's that Leon's case or Suntrack or whatever. I think they ran into that issue. But what I would do, very simple, I noted these things down, and it doesn't matter to me if it's meritorious or it's not meritorious. The one thing you look at, first of all, is the phrasing of the letter, and is it something that you usually run into as a real estate practitioner? Because if the wording seems different, and it may be some guy like me or Sternberg who's writing those letters for a practitioner, that could be a sign to you that this transaction is in trouble and going south. And you should pay very careful attention to whether or not you can answer the requisitions. That, to me, is the most important thing. Whether they've got merit or they don't, can you deal with them? And then I agree with everything else Allan said. Act reasonably, bend over backwards, offer solutions, throw it back at the other guy, and just try to and handle the file as much as you can yourself.
There's another issue, and I guess it's all part of my sometimes wearing LPIC's hat, and that is if you're the one who acted on the purchase. I hate acting on behalf of vendors where I acted on the purchase. Because the last thing I want to see is a requisition letter of something that I missed. But I think it's important that when you get that requisition letter and you think there is validity to it, you better report to LPIC. And the reason is by taking any step to try and fix it, to try and answer it, you may be, number one, prejudicing your insurance coverage. This is the last thing you want to do. And you can enlist their help to see how the matter can get resolved. Especially if it's a meritorious one, then you've got a real issue to be dealt with, and you got to see if it can be fixed, if there can be a salvage. Don't start bringing court applications on your own or taking other steps, which could, in some respects, prejudice the insurer. The other thing is, I find that often when somebody consults me on a title problem, on a requisition, it's really too late. I think that a vendor's and purchaser's application can be a very strong tool, especially on wishy-washy requisitions, especially if you know that somebody may not close and may stand on the strength of that requisition. I'd rather nip it in the bud early. I'd rather say, you know what? No bloody way. I'm going to bring a VMP. I'm going to give you my answer. I'm going to let a judge decide. I'm going to put it to you to come to court with that and see if that requisition is valid. Now, that's assuming that it's a gray area, but I've seen so many deals where people make the requisition, somebody doesn't like the answer, they do the answer, and they say, I'm not closing, I didn't like your answer. And then it follows a whole different path where guys like Allan and Stephen then start with pleadings and more pleadings and discoveries and motions and everything else. Where on a V&P, you can kill it off real fast.
So deal with it quickly. Don't let it, become a sore
That's
for
the point.
you.
That's the point. Don't be afraid to go to the litigator early and do the V&P if you think that somebody's pulling a fast one on you. Because otherwise all you're going to do is end up with a gray area and somebody looking to settle a long time later on the issue.
All right. Any other ways to nip it in the bud in dealing with requisitions?
Sorry, are we talking about files over $2 or $3 million, or?
I would do it on a house deal. I had a deal, as a matter of fact. It was not an insignificant deal. Somebody had agreed to buy a property for $1.1 million. This was in the 80s now, in the late 80s, so $1.1 million wasn't a big deal. Had a 6-month closing, and by the time closing came, the value was $700,000. And we made all kinds of requisitions, and if the other side had been astute enough, in my view, they would have VMP'd me on these and put me to the test. Instead, they didn't. I folded my arms and said, you didn't satisfy your requisition, and we settled it for half of $400,000. So I don't think we're talking necessarily about the mega deal.
Ask Reuben if the market's going up or down.
Oh, you can only tell from the papers. There are other ways other than, I just got retained on a file that's just been settled. I actually have one going on with Allan, but this is one that I just want to recommend. I just want to speak about. A client came to me. The agreement was already signed. The closing date was coming up. There was no representations and no warranties. But the client suddenly got really worried because he had heard from a neighbor that the property that there could be environmental contamination. And he was worried that if he closed the transaction, that he could be involved with a contaminated property. There was nothing in the agreement that really gave the purchaser the right to get out. So naturally, we did the usual things. We searched the title, saw the survey, and I saw an encroachment of a fence. So I immediately requisitioned, gave the cases about an encroachment going to the root of title, has to be removed. They wrote back immediately saying the fence had been removed. So that went That was a very fast answer. No, there actually was a fence on survey. I was actually thought I really had a good thing about possessory title and everything. They removed the fence. So what do you do? What do you do in the case that we just had, that your client is worried about closing a transaction where there's an environmental problem and you can't really see a way out in accordance with the agreement?
Well, you have to consider things like rescission. You have to start to consider whether or not this vendor might have known about this environmental problem and not disclosed it to you.
And that is the position I took. I didn't know if the vendor knew or didn't know. So I took the position that if they knew, and I could only assume they know, and if you were going to plead it and send it to the litigators, they would, we would plead that. And so we just took the position where we were not going to close the deal unless we were able to go in and do an environmental assessment. The key in that, that's very nerve-wracking. So now, if you tell the client to close and there was a real contaminated problem, could cost hundreds of thousands of dollars. If you don't close and the vendor didn't know that there was any contamination, then you, and even if you found out there was no contamination later on, you could be sued for the land going down in value. You could be sued for more than the deposit. So what you have to do is you have to weigh the risks, but the key is you really have to explain to the client the risks of closing, the risks of not closing. That is key, and you should make notes about it, and when it gets to that type of situation, you really should have somebody else, a student or somebody in your office, or you have directions, because if you don't close and you turn out to be wrong, the damages could be very, very high. And you know, Steve Brunswick and Allan have gone after purchasers. When the market went down, they acted for developers where somebody bought a unit for $200,000, didn't close, and the damages would end up with $150,000. They may have well closed. So you have to explain the risk. In this way, we actually had people that were willing to try to resolve it. They understood our position. They let us go in. We did a phase one. We found out that there was still an element of contamination. They let us do a phase two. We found out that there were tanks in there, and then after that, all we did is fight about who should pay the cost for the removal. But by that time, you're only talking about $20,000, $25,000. You worked out something with that, and the deal closed. So sometimes, because of the risk of litigation, because you don't want to send it to litigators, you really can work it out.
So what you're saying then is that litigation is not necessarily policy, but it could be tactical, right? In that case, the threat of litigation, it was a tactical maneuver for you.
Because you're explaining to the vendors, explaining it to the vendor's lawyer, explaining to the vendor, purchaser's lawyer, explaining to the purchaser, and waiting. Instead of waiting a year to get to mediation where the mediator is explaining that to you, you do it at that time.
The more interesting question is if the vendor doesn't cooperate and you have that, it's speculative and you don't have definitive evidence that the property is contaminated, and if it turns out, but you're so worried you don't close, and then at the end of the day, it was a $25,000 problem. You're probably going to lose your deposit, maybe more if they sold for less, and you're going to have nothing to show for it.
Well, let me just...
Can I just respond to that for just 1 second? That is, and what it is I spoke to the client. This is what really happened. I said, if you close a transaction, it's a serious environmental problem. It could cost you in the hundreds of thousands of dollars. If you don't close the transaction, I said, what's the property worth? He said, well, maybe 50 or 100,000 less. And so you assess those damages and you say, what is riskier? If we didn't get the environmental assessment, we wouldn't have closed the transaction. The risk was too high. When you're talking about environmental, the risk is too high.
Well, I wanted to move to a tangent to this sort of problem and others. And the tangent I want to move to is what's on the record. You're having conversations. You may be attempting to settle the matter, or you may be in a situation where you want to create a record for court proceedings if you think that that's where it's going to go. So the general question I ask, and it's a question that both barristers and solicitors have to know, what's on the record? What's not on the record?
Well, can I respond to that? Sure. I thought we weren't telling war stories, so I'm not going to really tell one except to say one thing. I'm dealing with a case right now that's got to do with an aborted transaction, and there's several thousand documents, and hundreds of them were intended to be without prejudice, and I now find them in the opposing party's affidavit of documents. And we may be able to sort that out as amongst ourselves, or we may end up on a motion about it, but chances are every letter that you write, you should write it with the being cognizant of the fact that whether it's without prejudice or not, it might end up in front of a judge, so be careful about your letter writing. And secondarily, if you want to deal with a topic that is without prejudice for settlement purposes or to address the resolution of an issue, deal with that in separate correspondence from any letter that you consider to be on the record, and for better or for worse, label it without prejudice. That's how I would handle it.
That's true. I'd agree with that. I take it one step further. Letters, obviously, letters between, when the real estate transaction itself is the issue in the litigation, I always thought that the whole file was producible. And then you say, well, the whole file, what about letters between myself and my client? And then you've got the privilege issues. And I've argued, and I think it is a gray area, that even those letters are producible. And for example, it's very, and I know we've discussed this at other conferences, when you're acting for the purchaser who's not going to close and is giving you those instructions, and then you want to cover your own rear to say, well, look, there's going to be a lawsuit here, I don't need an LPIC claim, or whatever, and then you go and write that letter to your client that says, look, you instructed me not to close, to take every measure possible to try and get you out of this deal. I'll do what I'm professionally able to do, but even if that letter got disclosed, which in one of my cases it did, that's the end of the case. Probably substantial indemnity costs. But if you don't do it, then the client comes back to you and says, well, it's all oral, and then some judge will say, well, you should have put it in writing. So you're damned if you do, damned if you don't. But Steve's 100% right. I would try and get every letter. Although I think even though I got that kind of letter in one case, my initial inclination, my belief is that it is privileged. I don't think it would be produced, but I'm not so certain. More importantly, what I'm worried about is conversations. What I'm finding more in practice, even with litigators, is I've always operated on the assumption that the clients have enough manure to throw at each other, and we don't have to get the lawyers involved. And I can't stand it when the other side puts into an affidavit what you discussed between counsel. And I naively assumed at the beginning of my practice that professional courtesy would dictate you wouldn't put those things in affidavits. It's understood that they're off the record, on the record, whatever that means. That isn't the case. Things are becoming uglier. So when you say things to the other side, as Reuben said in a case, I had a phone call with so-and-so, and he said, I'm not closing, and was laughing. Well, I guess to advance the interests of your client as a litigator, I says, oh, you're going to say that on the stand. So,
But
I mean, it makes a great way to practice.
But if there's something important to say, you should actually write the letter, and you should recite the details of the conversation in the letter and not leave it open to guesswork at some later point in time.
I think there's one other aspect, and we have discussed it before, and that is when you're starting to get instructions from your client to start pushing and shoving with respect to a deal that they may not want to go through with it, and you've got these instructions to throw every roadblock in the way. Or your client says, I'm not going to have any money, and you want to make sure that there is some kind of a record of that. My own view is you protect yourself first and not worry about whether the document is going to be privileged or producible or whatever. That's your client's problem. It's his litigation. Because at the end of the day, what will happen is this. If you don't do it in writing, if you don't do the letter in writing, then when the client loses at trial, the client will blame you because he will say, you told me I could get out of the deal. You told me I didn't have to close. And then your back is to the wall because you're having to defend yourself, and you didn't have any notes because you didn't want anything to be produced against your client in court. So if I have to choose between protecting my client's position and protecting my position, I'll worry about me first, and it's my client's litigation and my client's problem.
And sometimes protecting yourself protects the client anyway, because no one is suggesting that when you confirm instructions to a client that you're basically confirming that they're telling you to breach a contract. You should make it clear that they have contractual obligations and that you're going to act, as Allan and everybody else said, reasonably and in good faith. And even if that letter was to come out later, it can't hurt them.
Well, let me just expand on a couple of ideas here and offer an insight. I think that when a real estate transaction is going awry because the purchaser may not close and you're dealing with the record, I think the underlying thematic problem is multifunctionality and avoiding it. Because, I mean, there's correspondence that's for the purpose of settlement. If you combine correspondence that's for the purpose of settlement with correspondence where you're making demands and writing for the record, then what is that piece of correspondence? You can't classify it because it has a bit of both. Better to write, and I think this was Stephen's suggestion, better to write two separate letters. You may even stick them in the same envelope, but if you're writing for the record, you might specifically write a letter and say, I'm writing this letter for the record. It is with prejudice. I intend to rely on it. And this is my client's position on the matter, so that there's no doubt. And then you could say, and in a separate letter, you'd say, I'm writing for the purposes of settling this matter. And make it very clear. And don't have a multifunctional letter doing both. Because if you do that, then a court may put in a without prejudice letter, or conversely, and it may just be as much a problem, they may take a letter that you wanted on the record and treat it as without prejudice and take it off the record. Similarly, if you're dealing with your client, if you're reporting to your client, you want to keep it a pure solicitor-client letter. You don't want it to deal with matters that might be public record documents, because if you do that, you may find that that letter is producible when it was a pure solicitor-client piece of correspondence. So you really have to be careful about multifunctionality. Yes?
Is there any benefit to perhaps opening up a separate litigation file? Is that entirely separate? And any other correspondence after that initial problem arose should all be in that particular file?
100% right. That's what I was just thinking as Paul was speaking, open a separate file.
There's one case that Sid Troister was involved in where he wrote submissions that there should be leave to appeal to the Supreme Court of Canada. Anybody practicing real estate, it's just a horrible decision to my mind because it goes against good faith, but it was a lawyer acting for the vendor that wrote a letter that the court found wasn't appropriate. What happened is it was so obvious in this case that the purchaser said, I'm not closing the deal. Purchaser said, I haven't arranged financing, and the purchaser just said everything that I'm not closing. The vendor was struggling to see if the deal could work. So the vendor wrote a letter, and he said, look, I'll give you an extension. Ask your client if he wants an extension. But then he wrote in the letter that if you're not going to close, we're relying on the agreement, we're going to tender on you, and if you're not closing, we're going to sue you for damages. And so the person didn't close, he went in, he tendered on the closing, but he didn't have a discharge, he had a discharge, he gave an undertaking to discharge a mortgage exactly like the agreement said, except it was a Roynat mortgage. And the court held that a Roynat mortgage was not an institutional mortgage. It was not a bank, and it was not a trust company. So when the person tendered the undertaking, tendered the direction, tendered everything he was supposed to, did everything right, the purchaser didn't close, so the vendor sued the purchaser for deposit, for damages, and in the trial court, they won, which seemed to me the logical conclusion that the vendor should win. Acted in good faith, purchaser acted in bad faith. It was everything that we've been talking about, except it went to the Court of Appeal. The Court of Appeal said, vendor wrote the letter, says he's relying on the strict rules of the agreement. Well, he didn't have his tender there. He had a Roynat mortgage. He's out of luck, and the vendor acted improperly by sending that type of letter. Sid then did a phenomenal presentation for leave to appeal, but at that time the courts were interested in charter cases, not in real estate cases, so they never granted leave to appeal. Point of the matter is that I'm just trying, your letters have to be very, very careful. Make sure it's not an anticipatory breach, and make sure you're not saying something that you can't follow through with.
And live by the sword, die by the sword.
Question at the back.
On that question of tendering, is personal tender no longer required within the ERES world? And secondly, in the context of the other side, for example, you're acting as a sale purchaser says, my client doesn't have the money, we're not going through. You know, do you ask for waiver of tender? What exactly?
Treated as a breach.
Just what I'm going to do, I'm just going to repeat the question. I've been asked to do that because this is being recorded. So the two-part question, and the latter part is the classical question about do you tender and what's the current status about tender in real estate transactions, and whether you ask for a waiver of tender or do you tender. That's the second part of the question. The first part of the question is, what's the state of tender in an electronic registration world? If we deal with the classical situation
I want Sternberg
first,
to answer that question.
Yeah,
I didn't hear that first part, and I'm sorry you repeated it.
It's because you need a haircut.
we scared them. But I'll ask you the easier question. I'll ask you about the classical problem of you're now confronted with a situation, not in an electronic registration environment, but in the old-fashioned environment where the purchaser has indicated that he or she is not going to close. And let's assume because they believe that there is a valid requisition and you have not brought a vendors and purchasers application to resolve it, and they're standing on their requisition, and they say they're not going to close. Do you tender? How do you deal with that situation?
Well, the question I thought was, you know that the purchaser has expressly stated, we're not closing this deal. So it gets back really to Reuben's example. As a vendor, it's the classic contract 101. You're the innocent party to a breach. You can either accept the breach, and, well, I'm going to qualify that. When we studied contract law, you had a choice. You either accept the breach, say the contract's at an end, because the very act of the purchaser saying, I'm not closing, is a repudiation. You accept it, that's at an end. You wouldn't tender at all. You'd be stupid to tender. There's no necessity. It's a superfluous act. And you'd sue for the damages. It gets a little bit more interesting where it's not so clear-cut that what the other side has done is a repudiation, but we'll leave that for another time. If you choose, I guess, an election that you may choose and say, well, I'm not accepting the repudiation. The very act of accepting brings the contract to an end. If you don't accept it, then you must tender. You must show you're ready, willing, and able. You're going for a specific performance. But even that now would be maybe not the wisest move because it's very hard to get specific performance. You have to show the property's unique and things of that nature. So, I mean, if it's just, as a vendor, 99% as far as I'm concerned is you accept the repudiation, don't tender, relist the you're going to sue for damages, forfeit the deposit, sue if there's a deficiency over and above that, relist the property and get hire myself or I hate to say it, Stephen.
You have, yeah, okay, exactly. If you
All right.
if you want to go for the older guys, you go down to Sternberg. But I just want to, because and he may forget what you told him, but what he did forget, what he did forget to tell you was that's a generic answer, which I don't disagree with. But you have to look at the reason why the purchaser is saying it won't, or he, she, it, whatever, will not close the transaction. Because if it has something to do with what your response is as vendor, you've got to look at the materiality of the matter, okay? Because that will depend on whether you can accept, whether there is a repudiation, whether there is an anticipatory breach, or how you might move on from that.
I didn't miss that. I left that for you to pick up on. I said it was a gray area.
I'm going to come back to your question, but before I ask your question, let's deal with a tender in the context of e-registration.
Perfect. Ask me, who knows nothing about e-reg. From everything I've read about e-reg and what I've done about e-reg, I think that you've got to have all of your documentation in the system and message to the other side. I think that's key. I think you've got to have all your acknowledgments and directions signed and ready to go. And if I were really interested in seriously tendering on this person, I would have all the paper. In fact, I would probably do a paper deed as well. It may be in the system, but I want to prove to the extent that I can that I am ready, willing, and able, and I will bend over backwards to prove that it was your fault that we didn't close. It wasn't my fault. So have it all in the system, but you still got to be prepared to get in the car and go to somebody else's office and have the money, have all the papers signed, and have all the papers signed by your client. Of course, you need your discharges and everything else that goes with the regular tender, but I don't think the court is going to worry too much about the intricacies of e-reg, because at the end of the day, they're going to be looking at ready, willing, and able, and doing everything that's in your power to get that deal closed. No, I'm talking about the acknowledgement and direction, because don't forget, the acknowledgement and direction is something that your client gives to you so that you can then sign the deed. This is assuming we're dealing with a sale. If you're dealing with a purchase, usually it's usually the vendor who's doing the tendering as opposed to the purchaser doing the tendering. I've had to purchase as a tender I've had to tender as a purchaser too, where a vendor said, "I'm not closing. I can't answer your requisition." And then again, you got to go by the book. There's old case law that said if the vendor won't do the deed, then you do the deed. And you go to them with the deed and say, "Here's the deed that I want from you. You sign it." It's all in a matter of how you set it up in order to prove the fundamental question, and that's readiness to close.
All right, but there's a gentleman first, and then I'll work our way around the room.
I just wanted to expand on that question. I think what he was asking is what are the normal practices, which doesn't work so much for you, but basically when we've got an e-reg closing, we send the documents on a sale 2 or 3 days ahead with the keys, with the documentation, registration agreement, the document registration. It's all there. The day of the closing, you find out they're not going to close. Do you think you have to get in your car? I think that's really what the question is. Or if you deliver all of that documentation to the other side, they're sitting with it. Is that?
That's probably enough. I mean, at that point, you say, it's one more letter to say, consider yourself tendered on. You've got all the documentation that's necessary to close the deal, and the deed's in the system.
If you send it in advance, though, you should make sure they signed off on it.
Well, that's part of the DRA that you don't know about yet.
Of course. or hopefully won't.
But, you know that something is going to smell a rat as well if, for example, you don't get the DRA back from the other side. But it's all part of that same process. It's just variations on the same theme, I think.
All right, I'm going to take some questions from the floor, and there were some.
There's someone back there.
No.
All right, over here then.
Well, I think that if you're going back to what Sid said a while ago about prejudicing the policy and conversations that might put you out, I think he was saying it in the context of if you acted on the purchase and now are acting on the sale, that if something comes up that might go back to how you handled the purchase before you take a step, that you might want to send off the letter to Law Pro or call them and keep them abreast of what you're doing so that it's not construed to be a breach of the policy and hence your coverage.
I wasn't worried so much with the element thing. I was worried about these conversations between counsel and negotiations to settle. They should be without prejudice and off the record, even if you don't say so. But what I gather you're saying is that usually they get into the record in a court case, and therefore you can't talk as freely.
I think a more accurate way to put it is, I think you have to govern yourself, being aware that they may get on the record unless you're very careful, and that you should make it clear. The advice I would give is that there's certainly nothing wrong with having without prejudice correspondence or conversations to settle a matter, and that should in fact be encouraged. The difficulty is, or the dangerous area, is to make sure that everybody understands that that's what is in fact going on. And that, if you mix correspondence or conversations on and off the record, then you may find themselves where they go on the record when you don't want to, and when they, are treated in ways that are uncontrollable. So you just have to be careful, that's all.
I'd like to make one comment on that. Judges are not practicing law the way we have to practice and communicate. So there's one case that there was a condition until 4 o'clock. The lawyer for the purchaser called up the vendor and said, could I get an extension of the condition till tomorrow? And all the vendor's lawyer said, I have to check with my client, but I don't see a problem. He spoke to his client. The client said no extension. He called back. He said, I'm sorry, I can't give you an extension. That's exactly how we practice. So they waived the condition, but it came in a little bit late and went to court whether time was of the essence or not. And what the court said, because the lawyer said, I have to check with my client, which was fine, but because he said, I don't see a problem, they couldn't rely on time of the essence. So I guess what everybody's saying is we have to deal with our practice. We practice in real life with real clients, but we have to be careful what we're saying.
Well, it's a good question, because I'm sure if you accepted everything we said, you wouldn't really have to worry about any closings. You wouldn't be in practice. You'd be writing to Law Pro. You'd been asking your client who's saying, why are you bugging me? But I guess it's, look, I mean, you know with whom you're dealing, once bit, twice shy. You don't change your practice. You don't get sued that much, hopefully ever. And but there are risks. The last thing you wanted to do is to get into litigation.
Okay, I'll ask one more question, and if there is one, it'll be the last one. If not, we're going to wrap it up. Anyone with a question? Yes, sir.
Just a follow-up to what I asked before. In the context of tendering, if somebody says, I'll waive tender, I guess typically, a few times I've had this, it's usually the purchaser's lawyer whose client has disappeared or just says not closing on the end of the month. What's the, I guess, the legal significance of waiving tender? And again, in the context of the E-Res world, I think the ERA sets out stuff about tendering as a requirement, but is there a big deal to that?
Well, from my sense, the agreement of purchase and sale has the purchaser's rights in them, assuming this is a purchaser, and it talks about tender. So I'm not so sure a lawyer can waive tender on behalf of a client without instructions. So what you do is you say, I'm around, you want a tender? Come on over and tender. But to waive tender, the last thing, again, you want is your client to come back later and accuse you of prejudicing their rights. I mean, the Kwan case, which is what Reuben was talking about before, Kwan and Cooper, is a perfect example of a purchaser had no money, no documents. The lawyer could have been comatose, and that was it. He did nothing. He was not involved in this deal at all. And when the purchaser's lawyer said, when the vendor's lawyer said, I'm going to hold you to the deal, and came and tendered defectively, it was to his advantage. If the lawyer for the purchaser had said, I haven't heard from my client in like 6 years, I don't know where he is, he has no money, he's nowhere, I'll waive tender, guess what? The case would have been totally different. So I don't think you can waive tender without your client's instructions.
But assuming you had the instructions, or the other side got instructions, to answer your question, what's the significance of tender being waived? Well, it goes back to what Allan had said in a sense. Tender really is evidentiary with respect to several issues. It's evidentiary on the side to show that your client is the good guy. And if tender is being waived, then the other side is saying, this is the issue upon which we're refusing to close, and no other, in effect, because we're not testing you on any other issue. And what waiving tender will do, it will focus and narrow the issues. And, you can get to the same place without tendering by your correspondence and saying, you refuse to close for the following reason. That will be the issue in the case. Tender tends to narrow the issues. And if you're seeking specific performance, which is really a purchaser's issue, tender shows, once again, that you're the good person in the transaction, that you are ready, willing, and able to close, and therefore there's no equitable ground to deny you specific performance. So it's essentially evidentiary. You can avoid it in many circumstances because there won't be an issue. And that's what it really comes down to, I think.
Ladies and gentlemen, I'm going to thank the panel on your behalf. I thank you all for sticking by this program for 2 days. It was a bit of a haul. Hopefully it was a positive haul for you. And again, remember your evaluation forms. Thank you for attending and all of your attention.
Thank you.
Thanks.